Productivity, we don't have any accountability.
Accountability has been is limited to allegations of misconduct.
Okay.
Allegations, the performance of the job properly, nobody questions that, right?
How many cases, which are the kind of cases that you can do? Is it going to be constitutional case? And how many hours you are going to put in? All this is not there. One.
The powers of the court's administrative processes should not be vested with the sitting judges. They're already, burdened. I mean, they work extremely long hours. They work, they're very hardworking, and you don't have a minute's, free time. Who are in the High Court administration, right? I mean, it's a waste of judicial capacity, and we have problem with capacity.
It's a waste of talent, actually.
We have
the wrong place.
That's what I'm saying.
If there was this kind of a process anywhere else, they would have struck down in a minute. So what the process that is now being adopted, if somebody else would have done that, they would have struck down it in a minute.
Yes. We need separation between administration and actual judicial work. And judges should do judicial work. In the name of, sort of ensuring a judge's integrity, the interaction between the bench and the bar has become very warped. A vigilant bar is the biggest check on a judge. Does a judge come at 10:30 or at 11:30?
If you do 10 cases, there will be 5 persons who are disappointed.
If the English judiciary were to be subjected to the same tests as the English bureaucracy, he said a lot more people will fall.
Yes.
Right?
Yes.
So accountability is not an India judiciary problem, it's a judiciary problem across.
All over.
See, because what we keep saying is justice should not only be done, it should be seen to be done. Now, how do we going to convince the common man?
Appointment and accountability are two different subjects. Let the appointment process be started because it's a dire need now. A robust, transparent appointment process will definitely lead to accountability.
Okay. The discussion on anything to do with appointments may not be complete if we do not speak about accountability of judges. The things that I see in accountability is, what I see is today, we're only again talking of only High Court judges and the higher court, the Supreme Court. Productivity, we don't have any accountability as to how much a person, though you see, we take consent from the judges that yes, they're willing to be a judge. There is nothing to say what is it that you're willing to give to this post. How many cases, which are the kind of cases that you can do? Is it going to be constitutional case? And how many hours you're going to put in? All this is not there, one. Now, two is too much of additional administrative work is thrust upon judges. So therefore, they're not able to give productive work is what I feel, not that I'm speaking for them. You see, if you see before any court, the given judge is a member of so many committees, about 15, 16 committees. The judge is a member of, plus he or she has to do the judicial work.
Lot more administrative work.
Lot of more administrative than the judicial work. So that this takes a back seat. So that we are not having. Two is, the other point that I said, you have to be secluded in this socially conscious or rather social media world for a long time. It becomes very difficult to be totally away in this electronic world that we are in. You get tempted to say something.
Sainthood.
The sainthood can be punctured many a times as the... So that's why the tenure, as I said, was there. So these are the difficulties, I think, why accountability is requires to be discussed. So whom shall I start with? What are your thoughts on accountability? Of course, we can also touch upon the Judges 68 Act of Judicial Accountability Act and how the later amendment or bill which came about was never passed. And even today, that is also usurped. That powers under the 68 Act is also usurped by the Chief Justice. Well, I can use the word usurp because we have an act. As you said, if there was this kind of a process anywhere else, they would have struck down in a minute. So what the process that is now being adopted, if somebody else would have done that, they would have struck down it in a minute.
Yes.
But still, that is happening. So we don't know how many complaints If I were to ask any research student, give me what are the judicial accountability cases that you have, I get only 3. So is it that in 75 years or from 1990 or from 75 years, we've had so good judges that there has never been an issue? Is that what we are putting forth? Or there has been and we have absolutely no idea of it?
See, there have been many issues, and every practicing lawyer,
knows about it,
yes.
but never spoken or never written anywhere.
That's correct, because there are various problems with doing that, right? And I think many bar associations do bring up issues now and then. Then it's given a different color, it's given different allegations, thought processes, all of that. See, so there are 2 points. One, you raised both the points. Because you said, what is the accountability of the judge to the job?
What he brings into the job.
To the job, right? Is he or she performing well? That's one issue you pointed out. Then the second one is allegations of misconduct, right? And how do you deal with allegations of misconduct? And by and large, accountability has been is limited to allegations of misconduct.
Okay.
Allegations. The performance of the job properly, nobody questions that, right? And if a judge is performing suboptimally, then we just, shrug the shoulders and said, okay, we'll wait until he or she retires. Okay, and that's the risk of the system. Okay, and I think we can't do much about a judge being suboptimal. Because there are 2 things, right? One, you need to guarantee higher judiciary, judges in the higher judiciary tenure. I mean, they should have security over the tenure, the full tenure. And they should not be faced with unnecessary threats. Because that will compromise the essence of judicial work, which is you need to be independent and you need to have integrity in the work that you do. Because after all, you're deciding, you're dispensing justice, right? And in the higher judiciary, you're also dealing with the government as the major litigant. So for all 3 reasons, you need to give security of tenure. You cannot have dismissal or suspension for every other reason. Okay, so you need to. That's why the selection process needs to be robust. Okay, that's the reason why the selection process needs to be robust.
So are you saying that if the selection process becomes robust and foolproof, this problem will be automatically taken care of?
No, it's not automatically taken care of, but it is a what shall I say? It is a hope that somebody doesn't go rogue. Okay, and that faith we need to have. Okay, because as you rightly pointed out, we're talking with a very small number. We're talking about, including the Supreme Court, we're talking about, less than 1,200 people. Okay. And the Constitution, when the framers in their wisdom said impeachment is the only way of ensuring the removal. So you can't remove anyone without impeachment, and there's been no successful impeachment until now, right? And there's been only one proper attempt in the Parliament so far. All the others have failed even at the notice stage itself. The only impeachment process is just that of the former Judge Ramaswamy. That's all. So
no, there was one more judge from Calcutta High Court who resigned.
No, who resigned, but it didn't go through the process in the Parliament. That's what I'm saying.
I think it went before Rajya Sabha and then before.
I mean, the hearing, all that happened only with.
Final process did not.
Final process did not happen. The only full process, and where the impeachment failed was
the case of
Justice Ramaswamy, right? So both, and then you talked about are we burdening the judge with too much administrative work? I agree, and I think that is not a burden that has been cast about. That is a judiciary's own making, and there I have strong views. I think the judiciary, the powers of the court's administrative processes should not be vested with the sitting judges. They're already burdened. I mean, they work extremely long hours. They work, they're very hardworking, and you don't have a minute's free time. So I think the administrative process needs to be separated and managed differently. And other countries have shown the way. In the UK, it's a completely different process. A judge literally, I was talking to again another former judge of the Bombay High Court, and he said, listen, what does the surgeon do? He walks into the surgery,
Yeah.
he operates.
He sits and operates. So he's not
He
going
doesn't
to
prep, he doesn't do post-operative care, all of that, right? He operates and he leaves, right? So the case has to be prepped. I mean, look at it. I mean, all of us know, I mean, the first 30 matters, orders, whether, office objection in relation to photos have not been done. All sorts
Need
of
not
things.
be given to.
I'm just giving one example. What kind of computer should be purchased for the High Court? There's a committee, and
Drivers are also to
no, that's
be
correct.
appointed by
And
the
look
judges.
look at the number of district judges who are in the High Court administration, right? I mean, it's a waste of judicial capacity, and we have problem with
It's a
capacity.
waste of talent, actually.
We
in
have
the
a
wrong
prob-
place.
That's what I'm saying. He or she is much better off deciding cases in the district judiciary. Anyway, there are many other problems on the administrative side. I think so. We need separation between administration and actual judicial work, and judges should do judicial work. They may have to do some amount of administration, but not the
Maybe
amount they do now.
oversee or supervise or...
Even that they should not do. I mean, why? I mean, how is a judge equipped to decide what kind of computer should be purchased? It's incapable, right? And it's a waste of time to say, okay, painting committee, plumbing committee. It's nonsense, right? But that's one thing, and I think that needs to be separated. And we have proposed. I mean, through Daksh, we have proposed a lot of reforms on that side and changes, but that's slow to come. And initially with good reason, right? But now it has become a
cocoon by itself.
See, independence is important for judicial decision making. Some of it strays into some administration. So yes, that needs to be within the judiciary's powers, but not every administrative decision impacts your independence. I think that we are not realizing. So let's leave that for another day. You're talking about accountability. So in terms of the judge's performance on a day-to-day basis, I think it's very, very difficult to have any serious accountability.
No, not on a day-to-day basis. Overall, I mean, some commitment.
So
minimum guarantee performance.
No, there I think the bar needs to step up, and we are not stepping up.
I see.
We are the best check on the day, to ensure optimal performance by the judges within the normal course of operations. Right? And why do I say that? See, judges have gone from the bar, right? And this goes back to the seclusion point, right? In the name of, sort of ensuring a judge's integrity, the interaction between the bench and the bar has become very warped, right? There is no equal interaction, right? There is no honest interaction between the bench and the bar, either on subject matters or on the performance of the judiciary. Any interaction is viewed with suspicion.
Yeah.
If lawyers want to talk to a particular judge about certain issues, either there's some notion of allegation or they're doing some favors. So this mutual suspicion should go, right? And a more open atmosphere needs to be built. It comes with its own risks, but we need to go there.
Make an attempt.
Right? We need to make an attempt. That's the first point. Second point is a vigilant bar is the biggest check on a judge. Does a judge come at 10:30 or at 11:30? Right? This is something the bar can deal with. If the bar is strong enough in its own dealings with the judges, the bar should say, listen, please come at 10:30. It's causing a lot of problems to the bar. If 50 lawyers are waiting at 10:30 in court, and if there's no message that the judge is going to come only at 11:30, what is the point, right? And where is this mutual respect that we have for each other? So I think these things that the bar can deal with. So I feel that many of the issues that we are concerned about, we can do a lot more. We are not doing enough.
That is insofar as productivity. Now misconduct.
Misconduct, see, the nature of a judge's job is that in every case there can be allegation of misconduct. The losing party can allege misconduct.
Very unfortunate, but it does. Yes.
But that's the nature of the job.
Because there's always, if you do 10 cases, there will be 5 persons who are disappointed because they have lost. Who often says that the judge was, compromised and therefore very unfortunate.
And again, I think, the blame should start with the lawyer, right? Lawyers can't say, oh, influence agbitidare. It's the most common thing, right? I mean, first of all, we don't.
At least if the lawyer says that influence agbitidare, I can understand. They really put it in a very, very nasty way.
No, so that's
saying. That the judges compromised totally. It's very unfortunate. Not every judge will compromise, and then the judge is not going to look for your little case to be compromised.
See, many judges have told me sometimes they don't even know the name of the parties. They go with the number, writ petition number.
So many matters are there.
Which is true, right? So there are problems with the legal profession also. I mean, why do we take hopeless cases to court? I mean, that's one issue altogether.
Where
right?
do you draw a line as to what is the question of law?
There are many issues. So again, if the bar is strong enough, they can easily cut out half of the unnecessary dissatisfaction, right? But because the relationship between the bar and the bench has become so warped, what shall I say? So unnecessarily rigid. Okay, let me put it that way. So unnecessarily rigid, it is causing a lot more problems, which we are not able to see today, but it's causing a lot more problems. I think a more open relationship between the bench and the bar actually will take away some of these productivity issues. I'm not saying all, but some.
Yeah.
Some productivity issues, some unnecessary allegations that go on. But egregious cases of misconduct. And because the way society is developing, because the way corruption is accepted across the society, judges come from us, right? Judges come from society, right? So you can't suddenly expect a completely clean judiciary because you are in a society that today corruption rules the roost, right? I'm reminded of one statement by an English bureaucrat, by a former English judge, House of Lords judge, who said, if the English judiciary were to be subjected to the same tests as the English bureaucracy, he said a lot more people will fall.
Yes.
So I think it's not as if this is a India problem. So accountability is not an India judiciary problem. It's a judiciary problem across
all over.
So different people deal with different ways. We have said, okay, we'll only go down the impeachment route. And we have the process for Accountability Act and inquiry, all of that.
Judges Inquiry Act,
all of that. Now, again, there are issues of egregious misconduct. What do you do? And it's a very difficult question. There are no easy answers.
No, I think I was trying to test whether that also should be made more transparent as to what are the complaints that happen, and what does the Chief Justice do with those complaints. If the Chief Justice feels, yes, this is a complaint which is genuine and then takes it up, shouldn't because none of the reports of what they do the inquiry are in the public domain. So would you think if such a step is taken of putting it out in the public forum, there will be more accountability by the judge?
See, yes and no. And here I think, actually, something like the senior judges, you need to have strong senior judges, right?
Okay.
If the Chief Justice looks at a complaint and says, listen, there's nothing in it, he should have the courage to say there's nothing in it.
Yeah.
Forget about it. I'm not publishing this anywhere.
All right. Okay. And if there is something in it and then publish,
then he should have the courage to say, I will deal with it in this fashion.
Okay.
But what is happening today is that, and again, let's take it at different steps. The Chief Justice of the High Court is the first person who gets complaints.
A complaint.
The Chief Justice of the High Court needs to have enough conviction and strength to be able to say, this is rubbish, I'm not going to take it further, and write it that way. If there is something to be taken up, he needs to make sure that there is enough evidence against supporting the allegation. He should not, push it forward if it's on mere suspicion. And this is a subjective test, but there's no other way. So, we cannot afford inquiries against every complaint against High Court judges because of the nature of the office.
Or open the judges to constant scrutiny.
Scrutiny,
yes. No, what I was wanting to say, Harish, is that you are saying not to expose the judges for constant scrutiny.
See, there are 2 points there, right? One, in I think 89 or 90, I think the Bangalore principles of judicial behavior were adopted
In some of
right?
the conferences.
in conference, and one, judges should not hesitate to disclose certain things on a regular basis. For example, their material wealth, assets, it should be disclosed. So unnecessary allegations are not made. That's the first thing. So a judge, the higher members of the higher judiciary should not be scrutinized for every allegation that comes. But at the same time, you can't ignore every allegation that comes, because that's the nature of the job. So there should be courage of conviction with
By
the
the
senior,
chief, with all the senior
members
judges.
of the judges. I mean, maybe the top 2 or 3 judges.
So
They're led by the
essentially you're
chief
saying
justice.
if they are strong, that the rest will fall in line.
Yes, yes. So leadership by example. Well, there will always be some rotten
Some bad
apples.
apples, yeah.
Okay, everywhere, right? Now there are 2. I think your question has 2 aspects. One, what do we do with the really rotten apple? Okay, that's the issue of accountability, and
How to identify
how
the
to
rotten
identify
apple,
the rotten apple, right?
yeah.
And a mere error. For example, if there's an error in deciding a case, is that automatically a question of misconduct? It's not.
I would say no. Yeah.
That's why there's an appeal process, so the errors get corrected. All that is okay. So allegations of misconduct, mainly financial corruption and other forms of influence, is what are the serious cases, correct? And I think that there we have to trust the Chief Justice of each court to do some initial homework and have the courage of conviction to decide whether it needs to be taken forward or not. Okay, and we have to do that. One element that you can potentially include in this to make it more transparent is to think of involving 1 or 2 senior members of the bar at that stage. If the Chief Justice thinks, listen, I'm not able to fully understand this, and there is some
Of course, that
element
depends on the nature of the complaint.
Nature of the complaint,
Yes.
right? You need to involve them, and some element of inquiry has to be done. No inquiry is not a happy situation. Impeachment is also not a happy situation. Every case cannot be treated like an impeachment. So the act of inquiry, statutory basis for initiating inquiry was supposed to bridge this gap.
So the only element you're bringing is, in the present system is, you're saying where there are serious allegations, have the bar members, senior bar members, jurists, part of the committee which
Yes.
they have constituted.
Yes.
So that there is a bit of neutrality.
We need to bring in an element of neutrality.
And trust the
Trust.
members of the bar to that extent.
Correct. We need to do that.
So we were talking about the reports. Now that there's a report that will come. We have not, as to my knowledge, correct me if I'm wrong, there are no reports so far published on any committee that has taken any complaint into consideration. You think there has been any report?
When we have read the Ramaswamy report, the report related to Justice Ramaswamy.
Apart from that,
no. I think, if you look at recent years, I think there was a report that was apparently written and given to the then Chief Justice with respect to the allegations made against Justice Ramana before he became Chief Justice of India.
Okay.
It exonerated him. The report exonerated him.
That is a part of a case law.
No, this was a complaint made by the then Chief Minister of Andhra Pradesh against
right,
Justice Ramana when he was sitting judge of the Supreme Court,
yes.
before he became Chief Justice.
Yes.
Now, apparently the in-house inquiry exonerated Justice Ramana. It was never published. I think it was a missed opportunity. It should have been published.
Okay.
And it would have given a lot of confidence, not just to the lawyers, but even to the public at large, and there's a report that exonerated a judge. So why should we shy away from publishing a report that exonerates a judge?
So probably because you see that might not have been done just in case in a future if the judge is really found guilty on any issue.
No, but that's like beating around the bush, right? And hedging, you can't hedge.
And it'll only keep guessing. People keep guessing. For example, the misconduct of a complaint raised by a lady in House staff against a Supreme Court judge. That also was a report was made by the committee.
Correct.
But from what I know, that report is also not released.
And I think, see, okay, there are some issues of confidentiality and sensitivity in respect of the victim as well. Okay. Because it's an allegation of sexual harassment. That was an allegation of sexual harassment.
Just, I will stop you here. Insofar as sexual harassment is concerned, for common people or even for advocates, we have the POSH Act.
That's correct.
But the judges are exempt over there.
That's correct.
It's
but
not
it was
there.
a case of sexual harassment.
So what happens in such situations?
No, so see, in cases of sexual harassment, see, you don't know what the if there is if the committee concluded that there is a case to be made out. I am not sure whether they can publish it immediately.
Okay.
Then they can recommend future steps to be taken, because there's an element of sensitivity and confidentiality with respect to the victim and future defenses that the accused or the alleged accused can take. There I can understand that perhaps the entire report may not be able to
need not be published.
May not be
in a position to be
may
published.
not be able to publish it. So I think we need to keep the general law and what the issues of confidentiality there. But in other reports where either we talked earlier about judges resigning before the report comes out.
Yeah, those two cases.
Or allegations are made.
Yeah.
Or
So
even
that then leads me to another question.
Yes.
What if the judges resign in the case of I'm not getting the name of the judge who was a Calcutta High Court judge who resigned and everything came to a standstill. So if there is a prima facie case and then there is a report which has brought the judge as known to be guilty, and if the judge resigns, where do we stand? What is your thought? Should it be taken to its logical end? Or is there that we just give it up? Because that's what happened in the past few occasions.
See, my personal view is I don't think we should give it up. I think the report, if is complete, I think it has to be published. Because whether we like it or not, if a judge resigns in the midst of allegations, then the presumption is that he is guilty of something. What it is, we don't know.
No, could be because the judge also
he doesn't want to go through the process. He says it's too indignified to go through the process. That could be, but it's important to clarify. For what? Not for the individual judge. Now you are talking about the system. See, you are talking about judicial accountability. So because these cases are so far and few between, as far as higher judiciary is concerned, I don't think sweeping cases under the carpet is a good idea. Especially when reports are written, it has to be published, because that is
and taken to its logical end.
Correct. That is what it does. Two things. One, it gives confidence to the independent and fair judge that he or she will be protected despite allegations, if that is the case. Two, it will send a strong message to the people who are errant that you can't get away with it by merely resigning.
Or to the other judges.
To the other judge, that's what I'm saying. To the other judges also, that listen, this is something to be taken seriously and not just it's not just a written word on paper. See, that is how you build accountability. That is how you build the integrity of an institution. I mean, you are looking at an institution that should last hundreds of years. You're not talking about individual cases. Now, when allegations are made, yes, it is about the individual judge, but it's also about the institution. You have to ensure that the rights of the individual are not affected, but you should also keep in mind about what happens to the institution.
Because you see now so much of publicity or bad that's happened in the recent case of the burning money. What if the judge comes purely innocent?
I think then it should be published. It should be published.
What happens to the loss of dignity and all kinds of reports that are coming? Because you see, at the end of the day, a judge is a person who would have sacrificed so many valuable years of their life to serve or for a good cause, and then if their name and dignity is tarnished in this manner, what as society, how can we correct that in case the judge turns out to be?
See, I have a different perspective. I don't think it's any different from somebody going through the entire criminal process and being declared innocent at the end of it. Now, when you accept an office, you accept it with the risks and the rewards it brings. Now, yes, whether an innocent man should go through this process, no, you should not. But what to do? You are now faced with a situation where it has gone beyond the hands of some secret inquiry. You have constituted a public inquiry. Then the public inquiry, it needs to be, once the report is complete and the inquiry is completed, there are two possibilities. One, the individual concerned is found innocent, then publish it. Okay, what can the institution do? Institution can do two things. One, the institution who the representative is, apologize to the judge. That's the first, the individual concerned, and say, listen, sorry you had to go through this, but we have to, it's a larger institution at stake. Two, there was cash found burning.
Correct.
Then who is responsible for it?
Yes.
That needs to be
you couldn't have just let that have gone.
You can't
had to do something in this case.
In this case. Two, if the individual concerned is found guilty, I think all the more reason to publish the report, subject to criminal law confidentiality requirements, because you should not prejudice the judge in terms of individual concerned in terms of defending himself or herself. Subject to those rules of confidentiality, I think it should be published. That's the only way you build institution confidence.
And then take it next to the Judicial Inquiries Act.
Of course. I think I'm
even if the
reminded
judge resigns.
If the judge resigns, even more, right? If the judge resigns after the report finds him or her guilty of it,
then even more.
If the judge resigns because he says, now it's become too, stupid and I cannot continue in this job in an independent fashion, then that should also be made public. Because even that adds to the nature of future inquiries against such allegations. And that will help future Chief Justices come to a decision on what is the nature of the investigation or inquiry, right? See, everything can't be done in secret, and that is the problem. And otherwise, we will always have, you cannot have an inquiry that is self-serving. Unfortunately, we had a very egregious case where the Supreme Court Chief Justice, who was the subject matter of an allegation, decided to sit in the same in a bench.
And that report also was not published.
Thankfully, he, better sense dawned and he didn't actually sit in the court. But, we'll become the laughing stock. If you have not already become a laughing stock, we'll become the laughing stock. So, and this again, if it was relating to a bureaucrat, it would have been quashed by the judiciary in less than a second, right? You can't be a judge of your own cause. So we need to bring in outside elements to for example, the current Delhi, in Delhi, the situation we're all familiar with. The famous, burning incident.
Yes,
burning incident.
Which literally was burning.
Burning. If the Chief Justice he has constituted a 3-member committee, just imagine a scenario where apart from the 3 judges, there could have been an independent member of the bar, right? Could be from some other high court who doesn't know anyone, and ask him to be, him or her to be a part of this committee. That would have clearly lent an element of independence. I'm not saying now the 3 judges who are part of this inquiry committee are not independent. They're all very...
to bring in an element of neutrality
right?
to the whole process and the composition.
Correct. See, because what we keep saying is justice should not only be done, it should be seemed to be done. Now, how do we going to convince the common man that there is an element that justice was done by bringing in neutrality?
There was an opportunity which we could have.
We could have done, right? And that may require tweaking of the act, may require tweaking of the processes.
The process is now just a self-made process.
Self-made process which they adopt every time. For every new Chief Justice, there's a new process. For every new incident, there's a new process. Right? You can't make this up as you go along. Right? You need to have some clear rules and guidelines that says that this is how we will deal with it.
So let's
you can't
ask,
make it up as we go along.
Prashant, do you have anything
Appointment and accountability.
You have not made a PPT for us for this?
No, no. It's all his domain. Appointment and accountability are two different subjects.
Yes.
Let the appointment process be started because it's a dire need now.
So you haven't applied your mind for accountability
Yes, accountability can wait.
Huh.
The robust, transparent appointment process will definitely lead to accountability.
Okay, so you are
That's the
also
hope.
sending me a message that there are many other issues like reservation,
Yes.
equal representation for women, equality, all these issues are there which we should discuss. And what Mr. Prashant is telling is, today only process of appointment, I will apply my mind and think about these issues. But I
I'll
must
take
say,
some cues from him later.
yeah, I must say that it was such a intellectual interaction that we had. And I'm so glad that you have brought about a very nice process in place with a good, bad, whatever. And was this not a part of your article you published in
Yes.
VAKEELA VAAHINI a
Yeah.
couple of years ago?
Yes.
So it's good that you reminded everyone. Yes. So we can also put up which issue the article was. So
Yes,
if
it's
interested,
December 2022.
December 2022. So
Issue
VAKEELA
December.
VAAHINI can
Yes.
re-release that article maybe, and then everybody gets a benefit of what you have proposed. I would take this opportunity to thank Harish. Such knowledgeable inputs from your side.
Thank you
You've
for
been
having me.
working in this field, and it was so nice of you to have accepted in a jiffy to come here and spend a holiday, a well-deserved holiday with us. Thank you so much. And Prashant, of course, you are a part of VAKEELA VAAHINI. I shouldn't thank you. You should thank me
I
that
will
I
thank you,
have
yeah. Yes.
taken off my holiday. But I truly thank you for your time and this collective wisdom that we have trying to give it to the people.
Collective efforts and wisdom.
Okay, thank you.
Thank you.
you so much.
Thank you.
Thank you.
Thank you.
So for our viewers, as you have seen, there are many topics that are still pending within this broader topic that we have spoken. I'm so much passionate about speaking, giving equal importance and representation for women, about various other sections of society, then giving exclusive attention for meritorious candidates, and of course many more aspects of accountability. For that, we'll try and bring more and more persons who have worked on this field, and I look forward again with all of you to another podcast. Thank you.